I'm going to talk to you today about absence management, the legal issues and practicalities. Employee absence is a major concern for employers of all sizes, and particularly in the increasingly regulated employment environment. Many employers find it difficult to effectively navigate their way through the various issues that dealing, and in fact not dealing on occasions, with staff absences can raise. Including, for example, unfair dismissal claims, potential discrimination, particularly disability and sex, stress and personal injury claims, even before one goes on to consider the effects on an organisation's productivity, staff morale, management time and costs. Recent CBI estimates indicate that 168 million working days are lost each year through absence at a cost of approximately £12.2 billion. Those costs include the direct cost of lost production, the burden of paying company sick pay, the cost of replacement labour and the increased burden placed on non-absent employees, unnecessarily high staffing levels and overtime payments. In addition, there's general low morale and associated lower productivity. ACAS has identified the following results from analysing patterns of absence. Young people tend to have more frequent, shorter periods of absence than older people. Manual workers generally have higher levels of absence than office workers. Unauthorised absence is more common amongst new starters, with longer serving workers getting to know the organisation's standards and generally staying within the appropriate frameworks. Absence tends to increase where there are high levels of overtime or frequently rotating shift patterns, and absence is likely to be greater in larger working groups. However, via a structured approach, absence on whatever basis can be significantly controlled from the business management perspective and in a way that identifies, addresses and mitigates the legal risks. In this course, we will look at the various factors that need to be considered from the legal perspective and practically to achieve that approach. In looking at the legal framework, we'll start with unfair dismissal. There are many factors that an employer will need to address in dealing with absence. Ultimately, however, in some cases the question of dismissal will need to be considered. In assessing the fairness of any dismissal, an employment tribunal will have regard to the factors specified under Section 98 of the Employment Rights Act, 96, and in order to successfully defend an unfair dismissal claim, an employer must be able to demonstrate that the dismissal is for one of the potentially fair reasons under Section 98, that is conduct, capability, redundancy, contravention of an enactment or some other reason, the SOSRA reason under Section 98(1)(b). The tribunal will then decide whether the employer acted reasonably in treating this ground as the reason for the dismissal under Section 98(4). A dismissal for short-term absences is likely to be by reason of conduct or capability, though absences don't easily fit into either category if they're very short-term and consistent. The distinction is fine, and an employer may choose to go under the capability or conduct route. In terms of the fairness of any dismissal, initial points to note are that for a decision to dismiss to be fair, it must be balanced and informed in the light of the particular facts around that individual employee and their absence. There's no single factor that will outweigh the rest, and the following matters are often considered to be important by tribunals: consultation with the employee, the prognosis, i.e. what does the future hold, the length of service of the affected employee, the effect on the business, i.e. other employees, output, etc., health and safety implications, sick pay, has it run out, is there more to go, and also the question of alternative employment. We'll look at each of those factors in turn, and we'll perhaps start with alternative employment. Employees have a duty to consider employing employees suffering from ill health elsewhere in the company where employment can be offered in alternative roles. There is no obligation on an employer to create a new job, and in particular that was recently affirmed in the case of Tarbuck against Sainsbury's 2006. A failure to imply the mind of the employer to the question of alternative employment may be sufficient to render a dismissal unfair. In the case of Dix against Boots Chemist, for example, a store detective was injured after an assault, was off work for 3 years, and following consultation she was dismissed. the ET excused the failure of the employer to consider alternative employment on the basis that getting a doctor's report would have been futile, but the tribunal felt that that failure was substantive and allied to the question of not considering alternative employment rendered the dismissal unfair.